is something that is proven to be very effective during this difficult time. Since we are utilizing Zoom, I want to remind everyone that we will follow the same procedures and protocols as if we were in the courtroom. And if perchance, which we don't expect, any technological problems was to develop, everybody just be calm. We will take care of that, and we will remedy that, and no one will be prejudiced because of that. Before we start, though, I want to take the opportunity to introduce your panel for this afternoon. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Tivner, anything we need to take up before we get started?
No, Your Honor.
Excuse me. You may call the case then.
Christina Brooke Tigart versus Charles Shannon Tigart.
And we will hear from the appellant.
Good afternoon, Your Honors. Greg Smith of the Montgomery County Bar. I represent the appellant, Shannon Tigart. This is a post-divorce matter. The parties were divorced by irreconcilable differences in February of 2019. There was an unusual thing about the agreement. Mr. Tigart basically had agreed to do child support at $2,500, which is a little over double what the amount should have been. In August of 2019, the original plaintiff appellee, Mrs. Tigart, sought permission to move away and modify the parenting plan. The court held a hearing. As it did, one of the things that it did, they muted me back.
Yeah.
One of the things that,
just repeat whatever you said, Mr. Smith, because we didn't hear you for a moment.
Okay. One of the unusual things that the court did was allow almost double the child support calculation. Instead of it being about $1,250, by agreement, the parties made it $2,500. About 7-8 months later, the wife, who originally was imputed at minimum wage, husband was imputed at $10,000 for gross monthly income, wife receiving 240 days, husband receiving 125. In August of 2019, about 6 months later, she petitions to move to Upper Kentucky. The court has a hearing on it, and one of the things that the court notices, it starts reviewing its original order. There were several things that were overlooked on the original order. One being that at that time, Mr. Tigart had another child that was not factored into calculations. Insurance was not factored, and he had another baby on the way. The court originally recalculated, found a material change in circumstances pursuant to the mother's requested move. And when the court did, found that the child support should be around $1,250. One of the things that is a little different, though, the court also found that it increased the father's days to 140 days as opposed to 125, and then said that it should factor in the other child that wasn't originally considered, insurance, etc. Put in an order. And one of the interesting things that the court said on that hearing was that when I originally looked at it, he chastised both trial attorneys. I didn't handle this at the trial level, but basically said, I told you when you first started this, I don't like to go over the child support amounts, but since you all have agreed, I implemented it. When it came back through, obviously the court was looking at the move away statute, and the court said, well, I'll recalculate, put it at the actual amount of days, give the credits that were to be offered. The wife filed a motion to alter or amend, and basically the court found that it did not have the discretion to go back and look at its original child support calculations, even though it found a material change in circumstances. That's where we believe the court respectfully erred. The court was looking at 36.5.101G1 that says unless a variance has been court ordered, the court can always relook at recalculating if there's a 15% variance. The court found on actual calculations there was a clear 15% variance, but then went back and said, I see a material change, I find a variance, but I do not think I have the power, since there was an agreement originally, to change the child support. Respectfully, we take issue with that. First of all, when 36.5.101G1 talks about a court-ordered variance, we believe the intent of the legislature was the court found some reason for variance other than an agreement by the parties. Classic example would be intentionally underemployed. I went and quit my job for $20,000 a month so that I could be at $2,000 a month. That's not what happened here. The court made a factual finding that, one, it probably shouldn't have given the variance. Two, the parties and Mr. Tigart did not fully understand what he was doing at the process, and that it didn't factor in all of the points that should have been considered. Interestingly, when saying that, the December 17th, 2019, the second order gave no credit for health, dental, vision insurance, did give an in-home credit for the other child. And then on March 2nd, after the motion to alter or amend, gave no credit for insurance or home child and went back to the original numbers. What we're looking at, there were 5 facts that specifically the court found. As I say, one, no consideration in the original upper deviation. The court didn't find that there was a justification for it, just the parties had agreed to it. Second, that order was not in compliance with Tennessee child support guidelines. The original support orders were inequitable. The parties had, the appellee had relocated with the children to Upper Kentucky. There was another child, and that Mr. Tigart was exercising more time. All of these should have went into a complete refactoring, both of the guidelines as well as the child support calculations. Any of these, as I've set out in my brief, would justify a material change in circumstances and a new calculation. The court respectfully did as many attorneys do, and sometimes judges do. They will get the hindsight 2020 and start doubting their original answer. That's what happened here. The court looked back and said, well, now that I've thought about it, maybe I shouldn't have done what I did, so I'm changing the answer back. Just like with the LSAT and the ACT, when you start doing that, you change from the right answer to the wrong answer. That's what's happened in this case. We respectfully believe that the calculations are in order, or if the court does not want to modify and correct that at this stage, going to the second order, remand it back for a new calculation across the board. As I say, frankly, since that time, he's had another child. It was about a month away from being born last time we were in court. What we take the position of is that once the mother, and it wasn't the father asking to change originally, once the mother opened the door to say, I want to rewrite this, she really can't complain if part of the rewriting goes against her wishes in the process of trying to get what she's requesting, which was the move to Kentucky. And she did get that. Now, I'm going to just touch for a second on the appellee's brief, but before I do, are there any questions the court has of me at this point?
Don't
Can
think
you
so.
cite, Mr. Smith, a single case to me that says that a trial court can't enforce an upward deviation where that upward deviation is greater than what the guidelines provide for in terms of child support. Can you cite a single case for that proposition?
No, sir. And we don't take the position that the court didn't have the power to approve the order. We take position that the court 6 months later, when it reviews it and they're asking for a modification, has the discretion to say, let's rerun the calculator.
When you say they are asking for a modification, in this case, the mother didn't ask for a modification in child support. She filed a petition for relocation, and she understood that by that relocation, it may affect the parenting time, but she didn't request that the child support be modified. That was a request made by your client.
Yes, sir.
And let me ask you, and this is a little unclear, wasn't it conceded that his income is $10,000 a month?
And that was never contested at all. That's the amount of his income is not at issue. The issue is that the court, because there was a modification of the parenting plan that increased his days, that there should have been the calculation that went with it. And that being kind of part and parcel of the whole.
Can you cite to me a single case I can look at that says where a party has agreed to an upward deviation because there's a change in the parenting time, you then adjust the child support?
Not off the top of my head on that specific issue. I can say, though, that since it's part and parcel, that anytime there's a material change or a deviation of 15% up or down, it can be modified. And in this case, the court specifically found that if you do the calculation, there was clearly a 15% deviation.
But you've seen that statute provision that says that doesn't apply when we're talking about an upward deviation, haven't you?
Yes, sir. But that statute says a court-ordered upward deviation. This difference here is they had agreed to it, and the court, even at the time, was saying, I don't see a basis for this, but I understand y'all are agreeing.
Well, so once they agreed and it's entered in the order, is it not a court-ordered deviation?
I think it is a deviation. I don't necessarily think it's a court order when I think it's by agreement, like an agreed order. But yes, I believe the court can enforce its orders, but I also think it has the discretion to review those orders.
Go ahead.
Any other questions, sir?
No.
As to the appellee's brief, they did an offer of proof from information from almost a year after the fact that the court refused to take the information as testimony, but the appellee was allowed to do a offer of proof. Respectfully, appellee spent a whole lot of her brief focusing on her disdain for Mr. Tigart. As the court is well aware, very few people that are getting along perfectly get divorces. And as such, we take the position that the facts of record are what the court did and should review, not what happened or was considered a year to year and a half afterwards. I'll be happy to answer any questions. I'm at about 12 seconds.
I don't see any. We will hear from the appellee. You're muted. And still muted. There you go.
May it please the court, Steve Gursky of the Montgomery County Bar, and I represent Ms. Tigart in this appeal. And it's respectfully our position that the trial court got things right when it granted our motion to alter or amend. And what the trial court found at that time was that there was no material change in circumstance that would justify a modification of support. I take issue with Mr. Smith's contention that there was a significant variance, because we ran in our brief, we ran a bunch of worksheets with all the variables, and we don't think that they even get to the significant variance threshold. They keep asking for a remand because they want to throw in some insurance costs, which aren't there. There are no insurance costs that weren't included. And I think the worksheets were correct, and there's not a significant variance, apart from the deviation. So once the court granted our motion to alter or amend, it essentially put the child support back to the $2,500, which was what the parties agreed to in their divorce just a few months earlier in February of 2019. And I would submit there was significant consideration for that upward deviation. This was a marriage of, decent length. They enjoyed a good living during this marriage. And my client walked away from, a business that supported this family during the marriage. And she walked away from any request for alimony, didn't make any requests for that. But the parties agreed they wanted to make sure their children were taken care of moving forward. And that was the justification for this upward deviation. In the court's written order on the motion to alter or amend, the court, kind of recapitulated some of its findings from the evidentiary hearing that was held in December. And the court noted that Mr. Tigart was extremely evasive in answering questions about his income. At trial, the court had a lot of questions about his credibility and his veracity. And overall, there was an absence of proof that there was any material change in circumstance that would support, somehow now, dropping child support. The proof that at the evidentiary hearing was that my client was still, lucky to make minimum wage. She was still trying to find her way. She, for the most part, had been a stay-at-home mother. And the proof of trial ultimately was that the court found that Mr. Tigart's income was $10,000. The entire focus of our trial was trying to figure out what the heck Mr. Tigart's income was, because he made lots of representations that his income, I'm making $4,000 a month. And he was, significantly, downplaying what he was making. And ultimately the court, found that his income was $10,000. And they continued to challenge that up until January 28 of this year, when we had the transcript from that motion hearing. And then finally, at that point, we subpoenaed some bank records because they had pending a motion. They had a motion for stay on appeal, and they weren't posting a bond, and they said they didn't have the money for the bond. So, we subpoenaed some bank records, and the bank records were very instructive on Mr. Tigart's situation. And they reflected, greatly on, what his financial circumstances were. But, and Mr. Smith's right, that was an offer of proof. The trial court, basically thought once they conceded at that motion hearing in January of this year that his income was $10,000, the trial court thought, well, okay, we don't need those records. That's maybe moot because you've got them to where you wanted them. They admitted to the $10,000. I think the court erred. I think those records were relevant. I thought the court should have considered them. But here's what the court found, and here's what the proof was: that Mr. Tigart, for a decade plus, was working. His sole source of income comes from J&S Auto Sales. It's a business that that's the business that supported his family throughout the duration of this marriage. At the time of the divorce, everybody agreed his income was $10,000. And here's what the trial court knew about Mr. Tigart. At a time where he's not paying support to his family, he's got suite level tickets to the Titans. He's regularly going to football games. That was the proof. In the divorce, in the final hearing after the divorce, Mr. Tigart, now he was wanting to claim that he didn't understand what he signed. He didn't understand the dissolution agreement, despite the fact that he had a lawyer representing him. He tried to backpedal and say he didn't know what he was signing. He was tricked into signing it, despite the fact that his lawyer was recommending that he sign it. The court was aware that he was living, well beyond his alleged means, because he was going out to nice restaurants, the proof showed, with lots of people that he was paying for. He was taking trips out of town. He enjoyed the season tickets. And the court basically determined that his lifestyle after the divorce was, exactly the same as it was before the divorce. He was still doing everything that he possibly could. And I think the trial court took note of the Tennessee child support guidelines that talks about, well, when someone says, they're not making any money, but they're living a lavish lifestyle, spending money and have resources and doing things, and the court can take notice and impute income. And ultimately, what the court found was that Mr. Tigart, that his lifestyle had not changed. The reason for the upward deviation still existed, and that was to help these children have a decent quality of life. That taking away that deviation and, just going back to guideline support would have been, horribly disruptive to those children. Mr. Tigart's got the ability to generate a lot of money. He's been generating money. He's sure been spending a lot of money. And the court knew that Ms. Tigart was not going to be capable of generating that kind of money. So ultimately, the key factor in this determination of a material change, I think you have to hit the first threshold is you have to have a significant variance. If you don't have a significant variance, then you don't get to this material change. And the key factor for the material change is income. And they finally conceded that his income was $10,000. The trial court found him to be evasive and argumentative, Mr. Tigart, that is. The court looked at his tax returns, didn't really believe anything in his tax returns because the court noted that he's living high on the horse, contradictory to the evidence presented in his tax returns. It basically said it just doesn't add up. Mr. Tigart, he wouldn't even admit that he was an owner of J&S Auto. His partner is Jonathan Ross, and his name is Shannon Tigart, so you can guess what the J&S stands for, but he at trial denied he had ever had any ownership interest. We presented him Exhibit 2 at trial was the operating agreement from the business that showed that he was a 50% owner of it. These gentlemen, his partner, Jonathan Ross, he said, I don't recognize that signature. Even though my signature is notarized, I don't recognize it. I don't remember that document. And we presented documents from the Secretary of State to Mr. Tigart showing it was a 2-member LLC. And he said, well, we did it by handshake and we eliminated it by a handshake. So at one point in time, he says he never owned the business and now he doesn't have any ownership interest in the business. And ultimately, the court just found, that testimony wasn't credible. He had a Facebook page where he's posting that he's the owner of the business, but then Mr. Tigart said, oh, I don't have control of that. And again, the court said, I just don't believe that. I don't find that credible. And ultimately, the truth was Mr. Tigart never really could justify his spending habits. We showed at trial in this little window of time from February of 2019 through December of 2019, he probably spent, and I put this in my brief, about $86,000 that he spent. And that wasn't, his household expenses for food and clothing and gas. It was just other expenses that we could clearly identify that he spent. And then he's at trial trying to make up reasons, where that money came from. But the truth is, and the trial court correctly found that he had the ability to make money. And there was at one point in time, Mr. Tigart testified that if he ever needed money, he just went to Mr. Ross and he'll write him a check. And Mr. Ross, this is the same guy that fired 14 shots at my process server a couple of days before trial, when he was trying to serve him with a subpoena ducis tecum. So that's the proof that, Mr. Tigart presented. So ultimately, the trial court felt like Mr. Tigart was capable of earning money and that he simply wasn't credible. I cited in my brief the Wilder versus Wilder case, and that basically stands for the proposition that, look, if someone comes into a court of equity with, unclean hands, they should be denied relief. And respectfully, we think that case has application here. The next issue that I raised on appeal had to do with the trial court not making a finding of contempt. And the truth is, Mr. Smith wrote a good brief, and I understood the position that he set forth in his brief. We filed a petition alleging at least three different specific financial acts that Mr. Tigart didn't comply with. At the trial, they conceded that he hadn't paid $7,300 in support. That number was pretty much stipulated. They didn't contest that he refused to pay, some repair expenses to the house that my client had to pay, both obligations that he was court ordered to in the dissolution agreement. And third, there was a tax lien that he was obligated to, be responsible for, which ultimately the house sold, and my client lost, $25,000 because the tax lien was satisfied from the proceeds of the house equity. So the trial court ultimately gave my client a judgment for approximately $35,000 because we had to sue for it. We had to come to court and seek recovery of $7,300 in back expenses. We had to ask for $811 in repairs, and we had to ask for a judgment for the tax lien. Those were three obligations that he was clearly obligated to comply with, but he didn't. And on the motion to alter or amend, we asked the trial court to reconsider its ruling of attorney fees because we had to come to court to seek enforcement of, certain provisions of the dissolution agreement. And we cited to the trial judge page 9, paragraph 17 of the original dissolution agreement. And that paragraph said that if anybody has to come to court, to enforce any terms of the agreement and you're the prevailing party, the trial court shall award attorney fees. So the trial court explained that in its order, why it didn't award attorney fees, and basically said, well, we got to move. You should be happy with the fact that you got to move. Was kind of the underlying or kind of the overriding basis of the court's decision to deny, my client's request for attorney fees when she sought enforcement. But our position is, irrespective of a finding of a contempt, it doesn't require a finding of contempt for her to be awarded attorney fees for enforcing those judgments that we ultimately attained. And the truth was, they were contested. The $7,300, they fought us on it because their position was that, well, that's just child support and we're entitled to a retroactive modification. So we spent a lot of effort trying to pursue these judgments. We presented proof in the form of affidavit, as to what the attorney fees incurred were. And we think the trial court respectfully abused its discretion in not, complying with the clear terms of the dissolution agreement that said, that you shall be awarded attorney fees. We got a judgment for $35,000 for three separate things. And, we had to come to court to get it. So respectfully, we thought the trial court should have awarded us attorney fees, and that's what we asked for. And then finally, respectfully on appeal, we would ask that, look, Mr. Tigart, he's got us at a significant financial disadvantage, and Ms. Tigart would respectfully ask that she be awarded attorney fees on appeal. Thank you.
All right, thank you. We appreciate your argument. We will hear the rebuttal from the appellant.
Thank you. The original decree did not give credit for a third child. That was not factored in at all. There's no dispute that that should have been factored in. There was a third child in existence. It should have been one of the issues coming up. Insurance, healthcare, etc., is normally factored in. Mr. Tigart was ordered by the court to provide that, but was not given credit on the worksheet for it. As to the income information, we agreed that $10,000 should be his income, and that remained constant throughout. Even the hearing at the end, they said, we're not contesting that amount. We're contesting whether or not we should be getting credit. As to the contempt, respectfully, Your Honor, that is an issue that is solely within the trial court's discretion. A contempt is an issue that is an affront or an offense to the court. In this particular case, Judge Crozier made a factual finding. I've not been offended. I don't find a contempt. We do not believe on appeal that should be set aside. Finally, in regards to attorney's fees, both of these parties have expended considerable amounts of money. The reason that we came back to court was because the mother, Applee, filed a petition to relocate. So in regards to the attorney's fees that the trial court did not award, we think the court should be affirmed, and we respectfully ask that no attorney's fees be awarded here. I'll be happy to address any questions the court may have.
See none. Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and will issue an opinion at the earliest time possible. Again, we appreciate you participating by Zoom. Mr. Hibner, if we're nothing further for today, please recess court until the call of the docket in the morning.
This honorable court is now adjourned.
Thank you, gentlemen.